Good morning, Mr. Finch. Okay, you have unmuted. That's good. Did you wish to reserve any time for rebuttal, counsel?
Yes, sir. I'd like to reserve 5 minutes.
Okay, I've made that notation. Let me turn off the clock from the last argument, otherwise you'd be down already.
Yes, sir.
Okay. I will do my best to let you know when you get to the 15-minute mark so you can make whatever adjustments, if any, you think are appropriate. You may begin, counsel.
Thank you, Your Honor. May it please the court, my name is Alex Finch, and I was trial counsel for the appellant Webb Roofing and Construction LLC, and I'll refer to our client as Webb Roofing during the course of the argument. As an initial note, I'd like to advise the panel that there are currently about 16 of these types of cases, exact same issues. 10 of them are traveling together for oral argument on March 16th, 2021 before Judges Kelly, Morris, and Judge Andrea Smith. Neither appellate counsel nor I notified the court of related cases, and that was an error on my part. In addressing the issues here, Your Honors, the first issue was in the brief really wasn't particularly challenged by the defendant in their answer brief. In our position, Webb Roofing's position was that appraisal provisions are statutorily contractually created animals. There's no statute allowing a court to compel you to it. It's only parties agree to it. Also, the clear law here in the second DCA is that post-loss insurance claims are treated uniquely and specially. You can't restrict them. You can't prohibit them. You can't in any way limit them the right for an insured to give that claim to someone. Also, the law is clear in the second and in the fifth and in large part in the third and fourth that an assignee of a claim can take less than all of the contract provisions as a part of the claim. An assignee can ask for just only the right to collect on the claim. And that's what happened here. On page 18 of the initial brief, it sets forth the language for Webb Roofing's assignment of benefits, and it clearly says they receive the right to collect proceeds of the claim and to file litigation to enforce that claim. Under this court's decision in Nikon Construction versus Homeowners Choice, the second DCA also agreed that you can limit the assignment to just collection of a claim.
Mr. Finch, can you help me with kind of before you start going case by case, as an initial matter, why shouldn't we affirm just on the basis of kind of basic contract interpretation here, where it looks like the assignment here, it isn't just to the money of the claim, but it seems broader. It includes any and all of the insured's rights, benefits, and proceeds due. And arguably, at least, an appraisal provision in an insurance project or an insurance contract is a benefit insofar as either side may invoke it under its own terms. You seem to be viewing it solely in terms of it being an obligation, and perhaps when the insurer exercises an appraisal provision, it can be felt as an obligation, but it can also be used and invoked freely by the insured. So help me out here, because if I'm thinking if the shoe were on the other foot, and it was the insurer that was saying, no, we don't want to go to appraisal, no, we don't go to appraisal, I have to imagine Webb Roofing might have a compelling argument that it would, in its own right, have the ability to invoke and enforce that appraisal provision by virtue of the plain language of the assignment contract and the plain language of the insurance policy.
Okay. Webb Roofing would disagree on 2 points. One, the assignment of benefits, when you read the language, when it says all rights and benefits, that was one of the issues addressed in Nikon and in Shaw and in biosciences. When you say all rights and benefits, to what? Well, the assignment by its express language says to collect the proceeds, not any other provision within the contract. Under Shaw, by accepting assignment, the Shaw court indicated that by accepting an assignment of a right to be paid, the assignee does not obligate itself to perform any covenant under the contract. The appraisal provision is a covenant under the contract between the insured and the insurer. So here,
Let me jump in there and ask you then, and I'm sorry, Judge Lucas, did he answer your?
I can come back to it, Judge Lucas. I can come back to it after addressing Judge.
No, it's fine, it's fine.
I mean, it seems your argument says that the appraisal process just disappears. And that's where I have concerns, and I need you to help explain to me that at the point in time where the assignment of benefits happens, I know you argue, oh, they had time previously, but through the assignment, help me understand your argument. And I'm going back to, okay, basic law school, a bundle of sticks. You're saying, okay, you take part of the bundle of sticks and you assign them here, but they can't go back after the assignor. So what happens to them? Who would have that right for appraisal?
No one would have that right to appraisal after the assignment is completed. It remains intact between the insured and the insurer prior to appraisal. They could, an insurer can make a decision that coverage exists and go to seek damages under appraisal, which is all that appraisal is supposed to accomplish, at any time prior to assignment. Afterwards, the claim is no longer the insured's by everybody's law, including the second. So,
but the need for the appraisal isn't going to be known until a point in time where there's a disagreement, whether it's a roofing company or whoever else, the general contractor that's doing the work. They're not going to know until there's a dispute about that. So if the assignment has happened, you're saying it just disappears. Well, there's no more assignment, as Judge Lucas was saying, for either party. It's just gone.
That's correct, Your Honor, because you said the need for appraisal. It's not a need, it's a right. That's the argument for it. It's a contractual right solely created by contract.
But the need arises when one of the party feels like they need to invoke those rights. Because otherwise, if they're agreeing to them, there's no need. So the rights aren't needed to be invoked. But in your argument, they no longer have the right to invoke them.
Not against the assignee, because the assignee, by this express language of the, sorry, excuse me, Your Honor, the assignment did not accept assignment of those specific rights or other rights of the contract that might be needed to resolve a claim, such as to perform an EUO.
Help me out, Mr. Finch. How are you reading that in very narrow interpretation of what got assigned from the assignment that actually got executed? Because the assignment that got executed says, in consideration for the service performed, any and all of the insured's rights, benefits, and proceeds due to an insured under any applicable insurance policies pertaining to the insurance claim identified as claim numbered, et cetera, et cetera. So help me out. How are you reading that so narrowly that no, this only means the right to payment that was due under that insurance policy vis that specific claim, as opposed to what the language here says, which is, no, that Web Roofing is getting all of the rights, all of the benefits and proceeds.
Well, I'm sorry, go ahead, Your Honor.
No, go ahead.
Respectfully, Your Honor, you stopped reading the assignment. It does say that, but it says under any applicable insurance policies pertaining to the insurance claims identified as claim number with the claim number covering the loss sustained at the insured's property.
So going back to what Judge Stargell just said a moment ago, if this is indeed a right to appraisal, and it does seem to read that way, why doesn't it pertain to this claim under the express language of this assignment?
Because they didn't agree to that contractual provision specifically.
So okay, so now I'm getting your argument. Your argument is that unless the assignment specifies the actual covenant that is being assigned, it fails, notwithstanding language of generality such as the one that I've read a couple of times now. Am I understanding your argument correctly?
Yes, and it
Okay.
also tracks with the assignment of benefits, because it says that this transfer and assignment of right includes any right of the insured for extra damages, common law damages, statutory damages. Transfer and assignment allows the contractor to file a suit in the contractor's name to collect the proceeds. That language, the broad language of rights and benefits, that's been addressed by the Nikon Court, the Shaw Court, and in bioscience, all of them indicating that that broad language of rights and benefits must be read in totality with the rest of the language of the assignment. And clear from the Webb Roofing's point of view, clearly it says we've got the claim and the right to collect it and to go file suit for it, not to engage in appraisal.
Mr. Finch, so your argument actually, what you just told Judge Lucas, yes, that's true. Your interpretation would say that it's not assigned, but it goes further. And back to my point, it then disappears under your argument. It's not that it was a retained right by someone else. You're saying they have obviated a material provision of the contract by simply assigning part of the contract to somebody else. Explain to me how this happens, because it just seems to go against basic contractual principles.
Okay, well, here it's not obviated, it's an unexercised right. The insurer at any time from the point a claim, sorry, excuse me, Your Honor, is made, has 90 days to resolve a claim, to investigate it, to determine whether or not there's a dispute in some fashion. Excuse me. And within that 90 days, they could exercise the right. They generally don't. They don't generally exercise the right until a lawsuit is filed and you're 6 months down the road. So here they have the right to do it within the 90-day statutory period. They simply choose not to. And if they sit on the right and fail to exercise before that right, before the claim is provided to a third party, then yes, the Webb Roofing's position, it is lost because they have not, the assignment has not been agreed to. And I would say to the court here, the Florida legislature created the new AOB statute back in 2019. As a part of that statute, they specifically created a statutory obligation for an assignee to engage in appraisal as a condition of an assignment. Well, the legislature is deemed to know the status of the law. When that law was prepared, it created that right. It's not identified as a codification of any case law existing. So why would the Florida legislature create a statutory right if it was already within the contract and it must follow? In the defendant's, I'm sorry, the appellant's, excuse me, Your Honors, reply brief, they only have two arguments. One, that appraisal is preferred by the courts. I'm sure that it is. Everyone is sure that it is, because if you can get it resolved outside of a litigated environment, that can be more efficient. That certainly.
Go back to your question for a moment on why would the legislature pass a statute when it's already covered in the contract? I'm not following what you were getting at there. I mean, the legislature may have wanted to completely change the ability of people to enter contracts in a certain manner, but I just didn't understand what your argument was there.
Well, generally, the legislature doesn't draft things that are superfluous. If there are existing rights, they won't create an identical right in a statute unless they codify existing law, which wasn't done here. So by creating that right within a statute, Webb Roofing asserts that they're acknowledging that there is no such right or obligation of an assignee, regardless of whether it's in a contract, because it's simply a contractual right, one of the bundles of sticks that you can accept or not accept. Here, it wasn't accepted. The second
You are at 14 1/4.
Thank you, Your Honor. The second argument that's made by the appellee is that it's a remedial measure. and remedial measures must transfer. And they cite a lot of cases, but they're all arbitration cases. None of them deal with post-claim insurance except for one. And they're mandatory arbitrations, and none of them deal with someone challenging whether or not an assignee's challenge, whether or not they're subject to it. The Cone case is the main one they cite. That deals with debts that were subject to an assignment, and it was determined based on a statute under the UCC specifically addressing and compelling appraisal in that circumstance. So here, what we believe the court has determined is how far are you going to extend an assignment to inhibit the transfer of the assignment from the insured to the assignee. Here, if it necessarily follows that it's a part of contract, it must go. What other parts of the contract are necessary and must follow? The EUO, post-law statements. So we feel you have to make a determination whether or not you're going to restrict that transfer, because it's clearly a restriction. The assignee only gets it if they participate in appraisal. That's restricting the post-loss claim. You can restrict the transfer of a policy before a claim exists, but according to the law, specifically biosciences, you can't do it afterwards. So that's what we believe the court's left to consider. And unless there's a question that the panel has, then I would reserve the balance of my time. Judge Casanueva.
Thank you, counsel.
Thank you.
You are at 16, so you have 4 minutes remaining.
Thank you.
We will now turn to counsel for the appellee. Before I attempted to pronounce it for me so I get it right, I'm kind of sensitive to that with my name to make sure that I do my best efforts to get it right.
Well, I've stopped being sensitive to this a long time ago. It's Kwavnik, Your Honor.
Kwavnik. Thank you, sir.
Yes. May it please the court, I am Warren Kwavnik. I'm here on behalf of FedNat Insurance Company. Just so, I mean, it sounds like the panel understands exactly what Webb Roofing's position is. Their position is that when the insured makes an assignment of benefits to a third party, that effectively disappears or eliminates the appraisal process from the policy that was contractually agreed upon to determine the amount of the loss. The cases that they rely upon, Bioscience, Nikon, Shaw, none of those support this argument. They haven't cited a single case that supports what they're trying to do, nor is there a case that supports any of the links in the chain that form their argument. Their argument begins with the idea that they only assumed rights, none of the duties, and just like an examination under oath is a duty, appraisal is a duty. Well, it is not. That's the first place where they fail, and the 4th District in the certified priority restoration case dealt with that specifically and rejected that argument specifically. It's not a duty. The insurance policy sets forth duties as duties. What they have in common, other than the fact that they're placed structure-wise in the policy in that manner, is the duties are placed unilaterally on a party. They typically involve a requirement to provide information that's uniquely in the possession of one side or the other, or to take action like preserving the property, allowing access that's uniquely in the hands of the insured. And the policy says if you fail to comply with these duties, you might forfeit coverage. Appraisal is not specified as a duty, and it is not a duty. It's the mechanism that either side can invoke to deal with disputes as to the amount due. Appraisal is not even ripe until the post-loss duties have all been complied with. It's only ripe for appraisal when there's been an examination under oath if requested, an investigation by the insurance company, a determination as to how much the insured is owed, and a disagreement. Only then is appraisal ripe. We've cited a number of cases in our brief in a variety of contexts, some insurance, some UCC, all of which say uniformly that any assignment of benefits carries with it the agreed upon dispute resolution process. They've not cited any authority to the contrary. They could distinguish it on the basis that some of those are UCC, only one of them was insurance. That's a uniform proposition that fully is applicable here. And it's consistent, again, with the 4th District's case in certified priority restoration. The other point, and I think this is an important one, is I think as the court has recognized, let's say we treat appraisal as a post-loss duty. All that means is the duty to participate in appraisal remained with the named insured. It didn't disappear. And as applied in this case, it would mean that the judge still properly referred this case to appraisal. So how does Webb Roofing deal with that? Well, they say the AOB date and time just marks the point in time when the insurer can no longer invoke appraisal. And that's a made-up concept. There's nothing in the law or in the policy that says the insurance company forfeits its right to invoke appraisal at the moment in time when an assignment of benefits is given from the insured to a third party. There's a few important points to remember along those lines. We were told that there's a 90-day period during which the insurance company can investigate claims. Well, let's look at the time frame here. The loss was reported to FedNow on May 16, 2019. 4 days later, the assignment of benefits was executed. Where's the 90 days that counsel is referring to? In many times in a case like this, by the time the loss is reported to the insurance company, there will already be an assignment of benefits executed by the nature of these things. The insured suffers a water loss. They call a remediation company. It comes out. An assignment of benefits is signed right then and there, or maybe a day or so later, and only later is the claim reported. Although they're tacitly arguing that there's a mechanism to preserve the appraisal mechanism, their argument, let's make no mistake, is that there is no appraisal under this process. They just want to write it out of the insurance policy in an AOB situation, and there's no basis to do that. I would direct, and looking at their analogy, and it really is an analogy to the examination under oath cases, if you look at the 3rd District's case in Ifergain, that's 114 Southern 3rd 190, that case held that even after an assignment, the insured retained the duty to give an examination under oath, and failure to do so eliminated the right of coverage. Well, if they want to take the position that an appraisal is also a post-loss duty, which I disagree with, but if that's the position they want to take, then somebody's got to participate in appraisal. And if not Webb Roofing, then it needs to be the named insured. Now, frankly, I'm not sure why Webb Roofing would want appraisal to be conducted on its behalf by an insured who no longer has a stake in the outcome of the claim. But that's the implication of their position that they're taking, which is why they have to make the argument, which has completely no basis in law, that we just can no longer invoke appraisal after an AOB is executed. There's no law that they've cited to support that. It's completely contrary to the mechanism prescribed in the policy, and it's completely contrary to, as I've indicated, the idea that appraisal is not even ripe until all the post-loss conditions are complied with and there's a genuine dispute between the parties. They would effectively eliminate that entirely.
Mr. Quinn, Mr. Finch relies extensively on the bioscience case. In reading that, I read that case as simply answering the question whether an assignment that has language that appears to be similar to the language at issue here, whether that amounts to an outright assignment of the entire policy versus something less. And where we landed on in that case, as I read it, is that it's something less, and in that instance, it was payment. Is that consonant with how you're reading that opinion? Well,
yes, of course. The issue in the bioscience case and some others around that period of time was, can you even assign a post-loss claim? Can the insured do that? You cannot assign a policy pre-loss. And that makes sense. The insurance company has undertaken certain risks and charged a premium accordingly. And what the court said is when there's a post-loss assignment of the right to payment, that's not a transfer of the whole policy. It's a chosen action that can be sold and transferred, and we have no dispute with that in this case. We're not disputing the right to assign the claim. Bioscience said nothing about the issue that's here today, which is whether appraisal follows the assignment or not. Bottom line is, yes, I agree with Your Honor. All that case dealt with was, can you assign a post-loss claim? And the answer is yes. We're not fighting that in this case. And the other cases they rely upon are equally inapplicable here. The Shaw case says that an examination under oath doesn't transfer because that's a duty. Okay, and there's a number of cases that say that. The problem, though, for Webb Roofing is appraisal is not a post-loss duty. But again, even if it was, all that would mean is the named insured needs to participate in the so-called duty of appraisal. But the bottom line is, yes, Your Honor, bioscience, we have no quarrel with bioscience. It simply allows the assignment in the first place. under similar language. Now, by the way, I do agree with Your Honor's point that the assignment in this case is broader than what they're suggesting. It is a transfer, not simply of the right to receive a check, but all rights and benefits and proceeds under the policy. And I think the court has made a good point. If the shoe were on the other foot and Webb Roofing was the one trying to invoke appraisal, I don't think anyone would disagree that along with this bundle of sticks and rights, they took the so-called right to have the loss dealt with in appraisal. So there's that. But my view, and I think the law bears this out, is no matter how narrow or broad they try to craft their AOB to limit it to the right to receive payment, they cannot escape the fact that appraisal remains the way in which disputes are dealt with under this policy, either through Webb Roofing, which I think is probably the correct way to do it, or through the named insured with whom the so-called duty to conduct appraisal has remained. And once again, I know I'm repeating myself a little bit, but this idea that we use it or lose it by the AOB date is a completely arbitrary point in time that has no legal significance and is not supported by the law in any way. There's not been any argument as to today as to Webb Roofing's second point, which deals with the right to receive notice of the Department of Financial Services mediation program. So I'll rely on my brief for that. Going back to the first point, though, if the court has no questions for me on that, I suppose I would just rely on my brief for the remainder of that point as well.
Thank you, counsel. Excuse me.
May I proceed, Your Honor?
Let me finish coughing, if I might.
Oh, I thought you were done.
I don't want to miss anything.
Yes, sir.
Thank you, counsel. You may proceed.
Okay. First, to specifically address Judge Lucas's question on the all rights and benefits language in Nikon, quoting Nikon, it says, when the phrase any and all, open quotes, any and all insurance rights, benefits, and causes of action under my property insurance policy, close quote, is read in the context of the entire assignment and the purpose for which it was entered into, it is evident that the homeowner is assigning all his rights under the policy to payment for the service performed. That's what we have here. So
yeah, but you're reading that line as if it's a categorical limitation instead of an observation. You're saying that your argument is that you read that language to mean payment and only payment and nothing else, and that's not really what the court did, right? I mean, that wasn't even a question confronting the court, was it?
actually it was. It's to what extent did this assignment go? How limited was it? Was it dealing with?
Well, it wasn't the entire policy, and that's clear.
Right. But the issue before Nikon was, is it all or nothing? Is it limited in some fashion? In this case, was it limited to collection of payment, which is what we're arguing our assignment limits it to. And it seems to be on point. So I would respectfully disagree with the court on its interpretation of that language. Second, I'd like to address briefly counsel's statement about, well, the insured can come in and do appraisal as a post-loss duty. No, the law is clear in all the district courts that once it's assigned, they lose all right to enforcement of the claim. They are no longer indispensable parties. Judgments cannot be asserted against them. So no, they cannot enforce the claim through appraisal. The next issue I'd address is counsel continually said, was hinging it on it's a post-loss duty. Our brief doesn't say it's a post-loss duty. We say it's a duty. And every argument at the trial court is once invoked, the provision is mandatory. Rights aren't mandatory, duties are mandatory. So here, through the case law cited and the arguments made, they're asserting that it's a duty, not that it's a post-loss duty. So here, if it's a duty, our position is, case law says, post-loss duties or otherwise are not transferred to the assignee unless they specifically agree to it. Sorry, excuse me. And in the brief for the appellees, they say appraisal is the same as arbitration. Well, actually, under Allstate Insurance Company versus Suarez, the Supreme Court says, no, it isn't. It overruled some cases here in the second DCA and elsewhere where courts and the appellate court said all appraisal is arbitration and a property loss policy. And the Florida Supreme Court said, no, it isn't. They're different animals. They're statutorily governed. They have specific rules that go with them. And the cases cited for the proposition remedial measures all dealt with mandatory arbitration provisions, mandatory forum selection provisions, not a less formal appraisal right in a contract. So we would disagree that those are on point or meaningful. As to the final issue regarding notice, like the appellee, we'd rely on our brief. That was fully briefed for the court, and the case law that would address that. The court can certainly be apprised of the positions and what each side believes the law says on it. So we'd rely on that. Judge Castaneda, how much time is left in the rebuttal?
Actually, we just went past it, so your time has in fact expired, and I thank you for inquiring.
Okay, thank you. Thank the panel for its time, and we ask that you reverse the court's order and remand for further proceedings at the trial.
Thank you.
Thank you.
Thank you both. Please stay well. We hope to see you in the future.
Have a nice day.
You too.